My name is David Postalski. I am a partner at Gearhart Law. We kind of sponsor this entrepreneurial strategy series. So we're excited that you're all here. I want to just take a quick moment to have Elizabeth Gearhart maybe introduce herself as well. For some of you may already know her, but please, Elizabeth.
Hi, I'm Elizabeth Gearhart. I am married to Richard Gearhart, who founded the firm in 2006. As you all know, we do patents, trademarks, copyrights. And I've done many different things in the firm, still am, but my main role is to do the marketing for the firm. And I really cannot take any responsibility for this event. This is all David. We had started this a few years ago as an international law event that we had in physical places, and in COVID, David took over and picked up the ball that had been dropped because of COVID and really ran with it and has grown this event. This is our biggest one. Today is our biggest one. And kudos to you, David, for doing this. And we always get really super interesting speakers with great information that everybody needs to have. And I think that's why so many people attend. And it's just a great event. And we're glad you're all here, and we're taking questions in the chat, and nice to see you all.
Excellent. Okay, without further ado, if you've been to a few of our other sessions, we're kind of like along this journey of like, we had sessions around like, patents and trademark, like 101. We've had situations about how to make a prototype, how to manufacture overseas, we had a investor panel with two VCs and two angels. And so a lot of this is kind of being planned and kind of born out of the process and the journey that a lot of you are going through or have already went through. So I'm excited about these two speakers. I'm going to let them introduce themselves. They're a wealth of knowledge, and I'm excited for this kind of conversation. We encourage you to kind of ask us questions on the chat, and we will open it up later to live, so you can do that as well. But if you don't want to forget your question, you can just chat. Anyway, without further ado, very honored to have these two guys with us. I'll start with Mark because he's listed first. Mark, can you introduce yourself and let everybody know where you are too? Because it's pretty cool, I think.
Sure. Thank you, David. I really appreciate the invitation to today's event. Looks like you've got a great turnout and look forward to this discussion. I'm Mark McMillan. I'm a founder of Aqua Licensing. We're a boutique transaction advisory firm specializing in intellectual property, specifically patents. So we play in the secondary patent market. Our clients range from Fortune 100 down to startups and venture firms and private equity funds and so forth. Started the firm in 2013. We've got a global practice and help firms, buy, sell patents to balance out their portfolio. I'm calling you in from Panama, the Caribbean coast of Panama today. So we're enjoying beautiful, sunny, 85-degree weather down here.
Awesome. Thank you, Mark. We'll get into a lot of the specifics as to what Mark does shortly. But up next, Scott Crady. Please, I've known Scott for a few years, more than Mark for sure, but doesn't mean anything, but he's been a friend for a while. So Scott, please.
Sure. Thanks, David. Thank you for having me today, and really excited to be here for this lively discussion. As David mentioned, my name is Scott Crady. I'm founder and CEO of a firm called Magnitude. We're also a boutique firm focused on marketing and communications, and we've really positioned ourselves as sort of an advisor to companies, investors, and individuals. I'm an entrepreneur. I spent most of my career working in-house at companies and then got a crazy idea to launch my own thing. And 2 years later, we've got, a very strong stable of clients from Fortune 500 global companies to startups to one-man shows and investors. And we, in addition to blocking and tackling traditional marketing, we also work closely with startups in terms of fundraising. We work with venture funds to help them identify companies to invest in and so forth. And so I'm really excited to be here because my work in the patent space and the growth in the intellectual property space in terms of its role and its use as an asset has really grown tremendously. So just happy to be here and part of this. I'm based in the New York area, Westchester, New York. So certainly not as sunny here as it is down in Panama today.
Yeah. Actually, Scott, so thank you to both of you. Scott, let's actually, if we can start with you. Yeah, our title for the session is how to market your IP to investors, licensees, and consumers, your actual customers. But maybe you kind of touched on something I think that we should kind of get a kind of baseline understanding of. And a lot of the people on the call, just because I know some of them have intellectual property, but maybe just for the ones that don't, maybe you can talk a little bit about the importance of intellectual property, its relation to marketing. That's
Sure.
yeah,
Sure.
please.
So, as many of you know, intellectual property as an asset class has really grown tremendously over the past, let's say, 10, 15 years. You've seen the emergence of firms like Intellectual Ventures and RPX and a host of others create new ways to monetize patent portfolios, and they've almost really begun to be one of the key asset classes in the market right now. When you look at the value of some of these portfolios, you talk about companies like Nortel and the whole Rockstar portfolio, and the amount of money and demand that fetched from investors and potential buyers. You can see that there are lots of companies now where they derive their main value from intellectual property. I think it's the last research I saw was that maybe 70% or slightly more of a company's market capitalization comes in the form of intangible assets, such as patents, trademarks, and copyrights. So it's really emerged as an asset class. And so as you could imagine, then if that's your primary asset or value to a market, you really have to market and position it in a way that's going to hopefully drive value and grow your business.
Oh yeah, I was muted. Sorry about that. Mark, from your perspective, I think if you could, only because I get this question a lot from people on this, from the types of people that are on this call, which is, help me, sell my patents. Like I've tried everything, or I don't even want to get into the business of manufacturing production. Just help me sell. So you would consider yourself a patent broker, and if you do, can you maybe define that a little bit to everybody here so that they understand the differences in kind of the service that Scott offers and that you offer?
Sure. So there's a market we call the secondary patent market, and this is the buying and selling of patents from one entity to another. This could be from the inventor, a lone inventor, to a large company, or to what we call an NPE, a non-practicing entity, somebody who's going to monetize those patents through assertion. Large companies load balance their portfolio and will divest parts of their portfolio out. So if you're an inventor, you own patents, you'd like to sell them, the key thing is being able to articulate the value that's wrapped up in your IP. Are they being infringed? If so, by who? And what's the value of that infringement? If they're not, what benefit would they derive to a new owner? There's lots of different motivations that companies have to buy patents. Could be to monetize them through assertion. It could be for defensive purposes. Oftentimes, companies look to acquire patents that read on their key competitors. In case they get a claim against them, they can counterclaim and then begin negotiating. It could be because your invention would be a useful new feature or product for the buyer of that patent, and they're looking to buy that protection space to use it on an offensive basis. So lots of different motivations. And the first thing we do is really try to understand those, encapsulate those in our messaging around the portfolio. It's a buyer's market for patents today. The market's changed dramatically over the past 5 or 6 years. So the key to successfully market a patent or patent portfolio is you spend the time to understand the value, articulate that in your marketing material, and then go out very broadly into the marketplace. We have a database of almost 3,000 patent buyers that we can go off to, and to generate multiple points of interest to drive a transaction. IP is not a very liquid asset. It's not like selling your car. It's going to take months sometimes to drive a transaction completion. So it's be prepared to take 6 months to a year to find a buyer and get a transaction completed. Our firm has about a 60 to 70% success rate in transactions. The transactions that are the assets that are most commonly or successfully transacted are patents that are being infringed. So if you've got a patent that's being infringed by a lot of different parties, we can create claim charts. It's going to be valuable to the company who's infringing it. It's going to be valuable to their competitors. It's going to be valuable to patent monetization firms as well as defensive IP pools. But we have success in non-infringed patents as well, but it takes a little bit longer to sell the value inherent in them. So the approach varies really depending upon the patent, whether it's in use, the market that you're playing into, and the competitive dynamics of that market. So it's a very tailored approach depending on any specific engagement.
Mark, I want to stick on you for a little bit because we had this conversation before. A lot of what you're talking about of like, you actually use the word messaging, which is kind of a form of marketing, but at the same time, you don't necessarily consider yourself a marketing agency per se, yet you are marketing your clients' patent portfolios to a pool of kind of buyers. What's the difference to you there between messaging and kind of marketing, if any?
Well, I mean, we do market the portfolios. We operate like an investment bank, but the asset class that we're involved in are patents, right? So
yes.
we operate like any investment bank in any other asset class, driving a divestiture. We do buy side work as well, but most of our work is on the sell side. We get retained on the buy side as well. So we've got today we've got one of the largest automotive companies who is looking to augment their portfolio in certain areas. We know what those areas are, and we're off looking for patents that will help them expand their portfolio. But typical clients on the sell side. Yes, you have to market the portfolio. It's part of it. But it's understanding the value, the different buyers, and there's different value propositions based upon who the buyer is. So we want to identify all of the potential types of buyers, what the specific value proposition would be to each one of those buyers, and then we develop materials that help us articulate that value, and then create a comprehensive list of companies in that space that meet that profile, and then systematically go through and reach out to them to drive that message and make sure the opportunities would be. So there is a marketing aspect to it. We don't necessarily refer it, it's just part of the process.
Love it. Okay, great. Scott, it's all marketing for you, right? There's a strategy.
Yeah.
Can you talk a little bit about how
Sure.
a typical company kind of engages with you on that?
Yeah, I think that's a good question, and being able to distinguish between what we do and how Mark works with these companies is important. We're a traditional marketing firm, and if you think about the two pillars of marketing, they're really around two things. There's brand awareness and really creating an awareness of an organization and touch points with whether you're a B2B or B2C, those end buyers. And the other part of it is really direct sales, like creating opportunities to sell product, equipping a sales team with whether it's collateral or using a CRM to really engage your end customers. It's really to drive revenue. On the awareness side, you're talking about anything that will be used to soft sell, if you will, an end customer. So we deal mostly in the B2B space. In that mindset, it might be anything from developing a content strategy, which can drive visibility, give touch points with end customers through channels like social media and public relations, getting your name out there a little bit more in the press to create some brand awareness. And on the sales side, again, it's really just equipping sales teams with materials and the wherewithal to really drive revenue. But before you even get to that, you really need to really distill what a brand or a company or a product is all about. And then you get into things like messaging and value proposition and really building a marketing campaign from the ground up.
Okay. Can you talk a little bit more maybe about some of the differences in like strategies to like it seems that you're helping the company market to and client, to their future clients, yes, to potential licensees, possibly even investors. Can you kind of break down some of those differences?
Sure. I mean, for end users, it's really for customers, it's really about what problem is your problem? What problem is your product or service solving? So for us, for example, we do a lot of work with fintech companies that provide software or SaaS solutions that solve a problem around payment infrastructure, moving money from one place to another. So we would be delivering messaging to banks and other payment providers around how a client we work with, how their service really solves a problem for them, moving money faster, frictionless payment systems, more efficient, less expensive, and so forth. For an end user, for a customer, it's a totally different model where you're really, sort of focusing on things like what problem are you solving in terms of what's the end use for a customer, for example. So it could be a bank card, and this is more ease of use, or a digital wallet. It's something that allows you to really buy something or move money around in a much faster way and allow them to purchase a product or service more quickly.
Okay, and what about to investors?
Yeah, I mean, to investors, I'll give you an example. We have a new client that we're working with that's Series B. They've raised a couple of rounds. They're about to raise a second round. They're in the cybersecurity space. They have a patent portfolio, which is their primary asset. And we had worked with them to help them raise money by basically showcasing the value associated with the patent portfolio. So we would work with them and venture firms to really create things more about like pitch decks and more formulaic from a standpoint of like, okay, what's the potential return on the investment over, say, 2, 5, 10-year horizon to help them raise money.
Yeah, so this actually kind of begs the question. I think, Mark, you touched on it, and it's a really important part. I think everybody on this call needs to really understand just how important it is, which is the question being like, what makes your IP valuable, right? And that is the answer to that question really depends on a variety of factors. But I think, Mark, I kind of want to get it. I want to hear your thoughts on that kind of broad question. And then I think we need to talk about infringement, because that's like, other people infringing you is like a good problem to have. And so I kind of want to get into that a little bit,
Okay, so just to from a high level, patents on the secondary patent market can drive values anywhere from just a few $100s up to over $1 million for a patent. Okay, there's very few single patents worth more than $1 million in today's market. Okay, so what's the difference between a patent worth $1 million and a patent worth $500? Right. Fundamentally, let's look at what a patent does. A patent gives you the right to exclusively deliver a product or service defined in the claim of that patent for the 20-year life of the patent. That's what a patent does. It's a government's exclusive grant to give you the right to exploit that innovation for 20 years, right? If nobody's infringing it and nobody intends to infringe it, in other words, nobody cares about your innovation, it's of negligible value, right? So the first thing we want to do when you understand a patent's value is say, is it being infringed today? And so we do a patent infringement search. And oftentimes, inventors bring us patents and they've got a concept for their product, but a good patent attorney will look to broaden the claims out as much as possible. And oftentimes the patent claims are broader than the inventor's vision of his invention, right? Because the patent attorney's done a very good job of broadening claim language out. So we don't care about the invention. We care about the claim language on paper that was issued by allowed by the patent office. And so we do a comprehensive patent search. And if we find infringement, then we look to see, is the infringement worth chasing? Because if you're going to assert infringement against a company, it's going to you should be prepared for a litigation that could be anywhere from a couple million to 5 million, $6 million. So finding somebody who's infringing, a mom and pop company that's infringing, or a company, a small company in Shenzhen, China that's infringing, probably isn't worth going after. The costs are going to be more than any recovery that you can get. If we can find meaningful infringement, and oftentimes we'll do infringement analysis of technology and come up with billions of dollars of what we call covered revenue or infringing products over the life of the patent, then you potentially have a valuable asset. If we can't find infringement, so the next best step on the rung when we're looking at value is there a plausible logical case that this patent is in the path of future innovation? In other words, if you just sit there, will eventually the industry move on top of your innovation, right? If the answer to that is yes, then that's a little bit harder argument to make, but it's a decent argument and drives some value. If the answer to that is no, then you've got an invention. Your innovation needs to be evangelized. In other words, if you don't sell somebody on adopting it, it will never be adopted. Okay, and that's a difficult thing to do. Large companies don't want to talk to inventors who are trying to convince them that they've done something better so they can sell the patent. So they tend not even want to have those discussions because they've got their own scientists, their own PhDs, their own inventors who have a product roadmap. So that's those are the lowest value patents, or patents that are not in use, will not be in use unless you evangelize the adoption to another party. Sometimes we have success with that type of IP, but those are the lowest value patents. So the first thing you want to do is look for infringement. Look for infringement today that can be documented in claim charts. That's a chart that shows the patent claim mapped directly to a product or service, showing what we call evidence of use, where you take each element of the claim and you point to public evidence of the product using that element of the claim, right? If not, then we do this story of future infringement, show you're in the path. And if not, then you've got one of these technologies that needs to be evangelized, which is a much harder sell.
That was great. Thank you for that. I think that was really important for everybody to kind of hear and break down. Scott, do you get involved in any of that? Is part of working with Magnitude kind of understanding who the competitors / potential infringers are in order to kind of create that story that you create for your clients?
Yeah, I mean, we do get involved in competitive audits quite a bit. And I think really it reflects on the client we work with from a standpoint of their messaging and overall narrative they want to put out there in the marketplace, right? So that's really what marketing is about, is trying to create a unique value proposition, a narrative that really differentiates you and your products, and in this case, your portfolio, from your competitors. And so if patents and your IP portfolio are a big part of your company, your product, and your value proposition, then that's certainly a clear area that we will work on as it relates to the messaging, the story, their narrative that factors into your brand positioning. And it's something that we will focus on and really have it permeate through all the different aspects of a marketing program that we do, whether it be content development, talking to reporters, engaging with end customers as well. So yeah, it is an area that we do focus on quite a bit.
And Scott, what other kind of important aspects of intellectual property do you take into consideration? If not, like, we understand the whole infringement, competitors. Is there any other aspects about IP that kind of drive value for you and your?
We don't necessarily get that deep into it. Again, we try to unpeel the layers of an organization and try to identify differentiators. And if IP and patents are a part of it, then we will want to maximize those to our advantage. And so in the case of the cybersecurity firm I mentioned earlier, the cybersecurity market is very dense right now. There are so many vendors doing different things to protect infrastructure and systems, and rightly so, because it's a big problem right now, and it will continue to be. But not as many companies have a 24 patent portfolio that can have applications ranging from autonomous vehicles to instrumentation in airplanes. And so you can bet for sure that we're going to do everything we can to make sure that, you know, the messaging and positioning around the company relies heavily on this IP portfolio they have, because it really does make them unique, and we really need to play that up.
Okay, we've said it a few times, IP portfolio, right? I think I'm the first person to tell my clients, don't, you know, rely on just one patent. Let's think about ways to, you know, broaden it out and file continuations and try to get the most max, you know, kind of be your own innovator. I'm the first one to say that. But there's plenty of people on the call, I know for a fact, that just have one single patent, one product. Maybe it's not software, a consumer product, something like that, a CPG. Can you help people like that, Scott?
Yes and no. I mean,
you can say no. It's all good. I think.
Yeah, probably. Not so much. No, not really. I would say we don't get that in deep in the weeds if we do. Yeah.
Got it. And Mark, I imagine you kind of have the same approach as to the types of kind of clients you take on. You're looking for portfolios. You're not looking for one-offs.
Well, we will take clients with a single patent if they want to sell. If we view it as a, you know, valuable patent. So, you know, we have clients. Our largest transaction was about 12,000 patents. 2 transactions together from one customer was about 12,000 assets. But we have had many clients with single patents. For us to pick up a client and agree to engage with a single patent, we have to view it as a strong patent in an area of interest. But sometimes companies with a single patent, typically a company with a single patent has a specific patent covering their unique innovation on the product. Okay. And that gives them some level of protection from their competitive advantage on how they're innovating with their product. What it doesn't probably do is give them any protection on a defensive basis. So oftentimes we'll engage with smaller companies that have a single patent or a small collection of patents who are looking for defensive patents. A defensive patent doesn't have to read on your product at all. It needs to read on a company likely to litigate you for patent infringement. If you're building a widget and you have a patent that covers your innovative feature on that widget could still be infringing on many other patents on other players, right? So that patent doesn't give you any protection from being asserted against, especially if your company is highly disruptive in the marketplace. And an area where companies tend to get exposure is that when they finish their, you know, C round, D round of financing, they raise a few tens of millions of dollars. They've got a very small patent portfolio because patents take a long time to work through the process. And startups focus on their innovation, not covering their competitors. So if you're one of these companies who's, you know, now you've got a strong balance sheet, you've raised some serious venture money, you've got a young patent portfolio covering your unique innovation, you're about to disrupt some much larger international global companies, they may decide it's a good time to strike with a patent infringement suit, right? So oftentimes companies in this area they're buyers. They're buyers for defensive patents. They're looking for patents that read on the companies they're going to be disrupting, so that if they get an assertion against them, they have a counterclaim, and then they can begin a cross-license and negotiation as opposed to, you know, just paying out significant dollars.
Yeah, good. Thank you for that. And on that, just kind of sticking on this topic, I saw 2 or 3 questions I saw one from Antonio Perez, but it's all kind of related to the same thing. Are we just like, do you, Mark, and Scott, you can answer after, do you just work with, you know, patented, you know, granted patents, or can there be a mix of, you know, pending applications? There could be some international. How does that kind of all play out?
So, you know, if your portfolio is just applications, you don't have anything granted yet, it's really of nominal value because you never know what's going to be issued. Most patent portfolios have a mix of granted and pending applications. Pending applications have a value. It's probably on the order of, you know, 25% of what the granted patent is going to be worth, right? International patents, especially if they're in the right markets, they can have higher value than U.S. patents today. U.S. patent rights, because of PTAB, because of some other factors, have been significantly weakened over the past few years. So German patents, Italian patents, Korean patents, Chinese patents even today can have a higher value than their U.S. counterparts, depending on the technology, where the manufacturers are located, and the competitive dynamic, the vertical market that we're talking about.
Scott, do you want to comment on that?
Yeah, it's an interesting question. So we have found we've worked with a few companies that have patents that are pending, and we've actually found that they are almost as marketable as having a patent would be. So if you have the label patent pending on your collateral or product or whatnot, it can be directed both at investors and customers, really showing that there's some inventive aspect to it or some kind of inherent value associated with it. And so it can be a really great way to, tell consumers that, there's a special aspect or feature associated with it. So we have had a couple of companies we work with that have had patent pending, and we've really found that to be a valuable tool to market them as well.
Yeah, I actually tend to agree. I think it depends what stage you're in, for sure. Most of our clients are raising money based on, patent pending status, right? But then there comes a certain point, I think, to Mark's point, where, you have to have, you have to have eventually got it granted, and hopefully, there's that, potential for infringement, which is what we were talking about before.
Yeah.
Mark, I have to ask, and I'm sure people are probably wondering, aqua licensing. Tell us about if and what you do on the licensing end.
Okay, well, we do we'll call it friendly licensing. So our firm does not get involved in assertion work. Okay, we try to maintain positive relationships across the industry, right? And if you can think of the sort of the marquee technology firms, top 10 or 15 technology firms that would be up on most lists, we've done business with most of those companies, and we've got friendly relationships with the IP departments of all the leading platform, consumer electronics, semiconductor firms, and the like. We maintain that because we don't get involved directly in litigation. Okay. Now, to license patents today, oftentimes it takes litigation. We're living in the age of efficient infringement, right? Where you use it until you're forced to settle. But we do sell patents to NPEs. And in the industry, we either call them patent assertion entities or non-practicing entities. These are companies that don't build anything or don't build much of anything. They're in the business of monetizing patents through assertion. Okay, so when we pick up a portfolio on the sell side, we will offer it, unless we're told not to by our client, to patent assertion entities and non-practicing entities. And the operating companies, the companies that we deal with that build things, know that. And so they know if they don't buy or license the portfolio before it's sold, there's a chance it might go to a litigant, an aggressive NPE or PA. Okay. And so oftentimes we will, as part of the sales process, do multiple transactions. We just completed a large one, very large one last year, where there'll be a license prior to a sale back to an NPE, a sale to license to an operating company prior to a sale to an NPE. That increases the encumbrances. Encumbrances are the aggregate licenses of a given patent when it's sold. Because once you've licensed it, that license follows the patent to the new owner, right? And survives for the life of that patent, depending on the term of the license. So that's the type of licensing that we do. When we started the company, we were involved in more licensing than we are now. And the name sort of lived with the entity. So we've had some debates through the years about whether we wanted to drop the licensing component to it, because we don't want to be confused as a NPE. the derogatory term is patent troll. That's used outside the industry. So when I talk about NPE, those might think, well, patent troll. We don't use that because some of them are our customers. That's a group of companies that litigate patents.
Okay, Scott, do you get involved in kind of licensing or anything like that, or kind of marketing to licensors?
Not so much, but I will tell you that, to Mark's point, the term patent troll, there was certainly a negative, or has historically been a negative connotation associated with it. Sort of the good guys and bad guys, the trolls being the bad guys that just want to monetize these portfolios, and the good guys being the defensive aggregators to protect them and sort of hold them in some kind of a portfolio that allows other companies to tap into those in a more friendly kind of manner. Haven't heard as much about that world lately. It seems maybe, I don't know, Mark, you might know better than me as far as whether the tension or friction has calmed down a bit since the patent wars years ago. But we always come up against that in working with companies that have portfolios.
Yeah, Mark, did you want?
No, the battle continues. The NPEs will, they adjust to the environment. The NPEs, Intellectual Ventures was probably one of the largest. This is 7-8 years ago, and they were buying basically every patent that was on the market that they could find. And so being a patent broker back in those days, you just really needed one telephone number, and you could probably sell your patents. It's a much different market today. The pendulum has swung. It's now a buyer's market. It's not a seller's market. And you need a much more rigorous approach, broad systematic approach to successfully drive transactions. But there are still lots of NPEs. They tend not to pay cash on the front end. They like to split revenues, profit on the back after expenses. A typical NPE structure is something like you will get up to 50% of any recovery after litigation costs, right, on the back end. The risk with asserting your own patents is that if you're an inventor and you're manufacturing a product and you have a patent and somebody moves into the industry and begins to infringe on your patent, if you assert your patent against them, you will likely draw a counterclaim against you. And if you're a small company and you're asserting against a large company, they will use every legal trick in the book to drive litigation costs up to try to get you to back down. And then they will assert against you as many patents as they have. And oftentimes the small inventor, the small company loses on that deal. They get exhausted, right?
Yeah.
NPEs don't build anything, so they're not infringing any patents, and so they don't draw the counterclaims. Right? So oftentimes, small companies who have their patent rights being infringed on by a large company will sell that patent to an NPE. The NPE will then do the litigation and protect the original patent owner and the manufacturer from this counterclaim, and it'll be more of a fair fight. So the NPEs, although they have a reputation for being bad guys in the industry, they do serve a role in our current litigation environment from protecting small companies against just getting trounced on by large companies who are infringing on the rights of the smaller inventor.
Yeah, I agree, Mark. I think normally when I kind of present about, the patent troll phenomenon, there's always two images of trolls, right? There's like little Wishkin that's so cute and cuddly. And then there's like the evil ogre under the bridge, right? So depending on where you are in the transaction, it could be cute and cuddly, or it could be, an ogre. Could be your windfall as a small company for sure. So again, as I said, it's a good problem. These are good problems to have. That means your technology is, disrupting, and that there are potential infringers. It also, I think Mark also stresses the importance of like having good claims, right? Working with good people that, come up with this, patent portfolio with these defensive claims that kind of, make you stronger. And then there's we had and then there's the other phenomena of like litigation funding. A lot of our clients have been using that to kind of, help them with their, kind of defend the counterclaims
Mhm.
that are being brought against them. So yes, again, all good problems to have for sure. Okay, so Scott, there are definitely some companies out there, or even inventors, um, that are there's a lot of like, I don't know, PR around this topic that we're talking about. And some people think it's just like easy. I'm just gonna, come to Scott or Mark. I'm gonna show them my patent portfolio, and I love it. They're gonna love it. That's it. So I kind of want to get into like what makes a good client to you. Like what
Yeah.
makes the quintessential, a client for you.
Yeah.
Talk to us about that.
Well, I mean, for starters, I think a little bit of humility is always great, right? I mean, most of the companies and folks we work with at the very beginning think that they should be on page 1 of the Wall Street Journal talking about, why their product and service is so great and why they should be 6 times the size they are. But there's a lot to do before you get to that point. And, there's a lot of skeptics out there that, and rightly so, want to see you come deliver the goods beforehand. And so we level set at the very beginning and try to really play devil's advocate and ask questions like, why should I buy your product? What makes it different? We start off with any client we bring on, we start off with probably an hour and a half brand and message workshop where we ask lots and lots of questions, things like, what problem are you solving? Who are your competitors? Which audiences are you targeting? And we try to, make sure that they come up with the right answers, and we work with them to develop the right answers. And if we see responses that really don't resonate or aren't really unique or differentiated, we really try to call them on that. We keep going until we really are able to distill the messaging into a very clear way that differentiates them, because every company is different. The question is really distilling it down, trying to figure out what that differentiator is. For some companies, it's the people. For some companies, it's certainly the product or services. For others, it's sort of like the how, like what's the process by which you do it. So that really is what makes a good client, a little bit of humility and the ability to really be, introverted enough to really take a look at your company, your organization, your message, your product, and really be able to be humble about it and know that you've got to really build a very strong narrative from the beginning.
So, Mark, I have the same question for you, but I want to keep on Scott for a second. So, in this scenario, potential client comes in, they don't have the right answers to these questions. Are you passing on them, or are you like kind of working with them to kind of focus their answers?
Yeah, we do pass on clients when but usually it's about personality. If it's someone that we think won't be easy to work with or doesn't see the value in what we can deliver, really it's about the value we can deliver. If the company or person doesn't necessarily see that there's a need that we can fulfill, in other words, if they feel that we're just a means for them to get the message out there and that the expertise we bring is not really valuable enough, then we'll probably pass. But if it's a product or a service that we feel has appeal, we'll work with them and try to understand, how we can work with them to help them grow. That's really what we do.
Very good. Great.
Yeah,
No,
I'm trying to think of one other. I'm trying to think of an example. It's really all about humility.
Yeah, I agree. That goes a long way.
I think the thing is that ultimately the channel that they want to deliver their message to, whether it be an event they're speaking at or the Wall Street Journal or a trade publication focused on their industry, like those folks are going to be skeptical at some point. So whether it's us or them, someone is going to be posing very difficult questions. So we try to prepare our clients as best we can to be able to answer them and have, and really be able to do so clearly in a way that makes sense. Why are you different? What are you bringing to the equation in your service environment that isn't out there now? And why are you different? If they can't do that, then, A, it's an opportunity to work with them and help them do that. And B, they can clearly begin to see the value more.
Yeah. Mark, same question. What makes a good client for you? Who do you pass on?
Okay, so we actually pass on about 75, 80% of the opportunities that come across our desk. And, we get a lot of approaches, and there's really three main criteria that we look at. The first one is it a technology domain that we understand and we have contacts into the marketplace? So, we're Silicon Valley guys. We come from the technology space. We understand semiconductors, we understand software, we understand mobile communications, we understand sensors and those types of components. Now, that technology today affects most manufacturers of products, right? So automobiles to vending machines and all, Internet of Things, and it's a broad spectrum. But those are the technologies that we understand. If somebody brings us a pool cover or a pharmaceutical compound, that's not really our space. We don't understand that, and it would take us more effort to learn that area, learn that space, and than we could possibly make out of that. So, we have our sort of swimming pool that we play in, and if it's within that general space, then we can leverage our existing relationships and understanding to drive success. So that's first criteria. Second criteria is, does the potential client have realistic expectations? If he's trying to sell assets, it's common that most inventors view their invention as the most valuable thing that's ever happened on the planet, and they come to us and they say, this patent is worth $500 million, and we have to tell them no patent is worth $500 million. Okay, and talk through sort of the spectrum of value that we think is realistic and reasonable, not just from a value side, but also from a timeline side. If somebody's having cash flow issues, they've got some patents, and they say, I need these sold in 3 weeks, we need to make payroll, we're not going to be able to help you in 3 weeks. So are the expectations reasonable? That's on the sell side. On the buy side, is the potential buyer client, is he prepared to pay market price? Most of our revenue comes from success fees. We'll take a small retainer if there's claim charts or other things that need to be done on the front end, but overwhelming majority of our revenue comes from commissions on successful transactions. Okay, and so if we can't have success, it's not gonna be worth our while. That's the second criteria. And the third criteria is, are the assets on the sell side, are they quality assets? Are the claims crafted well? Are they broad? Sometimes you'll look at patents and claim one will, be 500 words long, or, and so complicated and convoluted that, nobody's ever going to infringe on it. So, we look at quality, we look at expectations, and we look at domain. And if those things line up, then and we think we can be successful, then, we're happy to engage with the client, whether he's got one patent or 12,000.
Good. Yeah. Yes. I think you both say important points. Okay. So
I would add one more
it.
thing, just to differentiate. We actually work on a retained basis. And marketing can be challenging, right? It can be, we'd love to connect what we do to return on investment. And sometimes we do. Sometimes somebody will be quoted in the Wall Street Journal, and somebody, potential customer will pick up the phone and call them and become a customer. And so there'll be a direct tie-in with revenue generation, but often it's the longer term planning and seed planting that we do that helps a company build its brand and hopefully its business and drive engagement over time. So it's much harder for us to charge on a, have a skin in the game, if you will, even though we'd like to.
Yeah, that's actually a good point. So there are some folks that are asking how to get in touch. We will send you Scott and Mark's contact information when we send like the recap in a day or two, or along with the recording. But some people were asking too how you all work with clients in terms of like how you get paid and stuff like that. So Scott, you only work on retainer? Is that right?
I wouldn't say only, but that's usually the structure that works optimally. And it's usually because we don't like to necessarily bill by the hour, because we're much more holistic in terms of the relationship we want to bring to a client. And I think, but a lot of companies in our space do work in a very transactional way. I think the model we have is much more relationship, where we do things that are outside of scope all the time. And I'd rather introduce you to a potential customer and pay our freight in month 1 or 2 than I would be to even, do an article or something that we might do with you. But we're very flexible as it relates to taking on new clients. We work with companies and we ladder up quite a bit in terms of what the fees might be in month 1, month 2 versus month 6 or 7.
Excellent. And Mark, can you talk a little bit about how a typical engagement works if someone were to hire you?
Sure. So I'll use our typical scenario, which would be on a sell side, right? So if a potential client comes to us and they already have an infringement analysis and claim charts completed, we will take, and we meet the criteria I told you before, we'll take that engagement on a success fee only basis. So if we think it works, and we'll get paid fully on the back end, and we get paid a percentage of the proceeds after the cash hits your bank, right? Now, if the infringement analysis and the claim charts and all that work needs to be done on the front end, we'll do a fixed fee, single fixed fee, a fairly moderate, to cover part of the expense on that. And then that would be deductible from the commissions on the back end. We are happy to work with quality work from any attorney that comes in on the infringement analysis and charts. Sometimes there's some offshore suppliers for claim charts, and they're cheap, but the work product isn't worth the paper it's written on. So quality evidence of use is expensive to develop and takes time. And those retainers, we are typically fairly cost effective on that. And again, it's done on a case by case basis. So, but 90-something% of our revenue comes from commissions on the back end.
Excellent. And Mark, can you have an interesting program going on at your company. You call it the investor pool. Can you talk a little bit about that?
Great. So I mentioned earlier in the day that we've got a seller's market now that due to weakened IP rights and some other factors, a lot of large companies are selling patents, and so we set back a couple of years ago and thought about how can we move these these Fortune 500 assets to startups, because startups, as I mentioned before as well, once you start raising some serious money, your CD round of funding, and you're putting tens of millions of dollars on your balance sheet, you're beginning to show up on the threat radar for the companies you intend to disrupt, right? Chances are your internally organically grown patent portfolio reads on your unique innovation. So by its very definition, it's not going to be of any defensive value against a large company that you're going to be disrupting, because their solution predated yours. It might have predated the founding of your company, and you're breaking the way they did things with a new innovative approach, and you're going to be disrupting their business, and you might be infringing on some of their patents. So we've developed a program called the IP Investor Pool, and the way this works, any startup can come to us and tell us the companies they intend to disrupt. We have over 150,000 patents in this pool. Companies like IBM and others are participating in this. And what we do is we've got some internally developed tools that allow us to look through this set of patents owned by these companies and look for assets that read on your competitors. Okay. We then can give you a cash price quote for these patents. Now, as a startup, you probably don't have a lot of cash. So the way this works is you enter into a patent purchase agreement where the closing of that transaction is dependent upon your next funding round. And the seller agrees that if you have an arm's length funding with a venture capitalist, that he will agree on that equity pricing and do a cashless transaction where he becomes an investor in your next funding round. Okay. So let's say we bring you patents and they're worth $1 million. And you agree that those $1 million of patents will actually be accretive to your balance sheet because they're going to read upon the companies you're disrupting. The patents have a priority date that may be before the founding of your entity. They may go back a long way, but they're going to give you some insurance protection against litigation from the companies that you intend to disrupt, right? So you agree this is $1 million worth, and it may have actually, because you can sign the patent purchase agreement as you're doing the subscription for your next funding round, and you can show the seller as a strategic investor. The idea is it can be accretive to your valuation on that funding round. So if you can increase the enterprise value of your company by say $3 million by having this $1 million purchase of assets on your balance sheet, you win immediately, right? So you sign. Go ahead.
I was just saying, I love it. I love that. That's great. That's how it should be. It just sorry to interrupt. Is that like, can like folks search the IP investor pool to see if they have related technologies on there that are worth purchasing?
No, we manage the list of assets. If you contact us, you tell us the names of the companies that you intend that you will be disrupting, who your competitors will be. We go through into the search, and then we come up with a cash price offer. Once that's negotiated, then the final patent agreement gives you up to 6 months to subscribe your next investment, and then the transaction closes. And you basically buy them in equity.
Love it. Love it. That's great. That's brilliant. Everybody should check that out for sure. I'm going to open it up for questions. Actually, Mark. Prolix, how are you, Mark? Are you there? Mark P, you're the first person to ask a question on the chat. So I wanted to
I was gonna be, right?
Totally. I wanted to give you the opportunity to possibly, if the answer hasn't already been given to you, if you have any questions, please go for it.
I still have to harp on that same question before.
Sure,
is that we're a small business. We have one patent pending. We don't really know because David is actually doing the work for us. So we've bought into the service to have him look into that patent for its provisional, right? The provisional is what we're going for. We've got 1 year to actually get stuff done and get the value up. What we're kind of focusing on is what can we do to increase the value proposition and the interestability of our little business to somebody who might see this and go, there is nothing out there like that. We like that. It's in a software space, software as a service space. We really like that. We'd like to get involved in that right now. What can we do as owners to drive the value up to the point where, they can't say no?
Scott, you want to take a crack at that first?
Sure. I mean, two very semi low hanging fruit things. One is you could become better known in the space, get some visibility through the press, whether it be a trade publication that covers the patent space or an IP or tech reporter at a mainstream publication. The other thing is I would find ways to tell the story, right? Can you do a case study or sort of a testimonial or walk someone through like a video of how you've worked with a customer and sort of explain how the IP has driven value for them? I think that would really, those two things would be two things I would start with. That would be things that could drive value for you.
I like both of them. They're very good. Mark, anything?
Well, I would just say, it sounds like you're a fairly early stage. And have you released your product yet into the marketplace?
No, we're kind of holding back on that. We have yet to fully develop it. We've got all the storyboards down. We've got the functionality of how things are supposed to happen. We just now got to connect the dots automatically and do everything that we said in our requirements that we're going to do. So we have a development company. They have graciously said we will take this on so that they're getting sweat equity out of this and part of the company. I myself am the technical developer because I've been in medical device and pharmaceutical companies for about 30 years. So I know this space really well. So I'm hitting on all my strength of what I know and what is needed out there. But yeah, we're still small, one patent, and we're just trying to make us as strong as we possibly can so that we've got basically a couple, three different exit strategies. One, if somebody sees this and goes, wow, I want it right now, what's our now price? If we go ahead and keep funding this ourselves organically and grow it to the point where we've already got interest in people who want to buy into this as sort of a pre-beta kind of a thing, we've got people interested, that we know the people in the industry that want this. And then, realistically, we can just go on down the road and we can just keep cracking on, getting subscriptions and just keep making this happen in our own right, so that now if somebody comes along and it's a fully developed thing, the price is, even higher. So we've got that multi-stage pricing in our heads of what we would accept, but we're just trying to figure out what exactly we can do to drive the value in this as much as we possibly can.
Okay, so first and foremost, focus on your product and make sure that you've got a quality product that is going to solve your customers' needs and is going to be differentiated. The patent then is going to give you some protection on the level of differentiation. What are you doing different than everybody else? And as you work with your attorneys, make sure that the claims are as broad as possible, right? If you have overly narrow claims, it's going to restrict the value. So you want your claims to be as broad as possible, and then try to look out, where's the industry going? Extrapolate. What's this industry going to look like in 5 years? Patents are 20-year assets, right? So don't just think about the first generation of your product. Think about where's the industry and technology going to be going 5, 10, 15 years from now, right? And try to anticipate that in some of the secondary and third claims, right? So cover your innovation on your first product, but then look forward and try to get coverage on the future, right? And if you're right, if you extrapolate correctly, that's going to be a valuable patent out in the future. So, broad coverage on your initial claims, cover what you're doing unique, make sure that you've got a quality product, because if you go out and you fail in the market, that's going to, because your actual product doesn't work or doesn't solve problems, that's going to detriment your patent value as well. So focus on your product, make sure your base claim covers that differentiation, make sure it's as broad as it can be, and then just brainstorm out, think 5, 10, 15 years out, and really try to extrapolate out. Is AI going to play a role? Are other technologies going to be playing a role? And how can you craft claims that are going to cover the future of your industry, right? And if you're correct in that, then you'll have a very valuable patent.
Well said. Thank you, Mark. Actually, we've talked a lot about patents. We get it. It's all about patents. But let's talk a little bit about soft IP. I know Mark doesn't get involved in that. Scott, your brand, your copyright. There are some people on this call I know that they don't have patents. It's all about their branding. Can you talk a little bit about that and the importance of that?
Yeah, I mean, if you think about big brands like I don't know, I pointed out a couple of examples. We talked about Lego and Coke, for example. Yeah. I mean, Lego has been sued countless times about their around their intellectual property they have, and Coke too. And surprisingly, Coke doesn't even have a patent on its formula. It's intellectual property revolves around its name and likeness and the bottle and packaging. So, how you present your brand and how it distinguishes itself in the market is really important as much as the product itself. And so, we don't get too in depth in the weeds with these folks, but we do have some entertainers and composers that we work with. And, they've copyrighted their songwriting, and it's a big part of their asset class.
Yeah. Thank you for that. Because you will all live and die by your brands for sure, before you even get to the patent question sometimes. Mark, it's interesting. Actually, I'm going to ask Timothy. Are you still with us, Timothy Gill? You were on camera before. Timothy, there you are. Do you
I
want
am
to?
here, yes.
Yeah, hi. Do you want to ask your question? It's right there in the chat, the one that you
The
chatted.
first one?
Yeah, I think it's
I asked two.
important.
The first one was if patent buyers treat pro se patents differently. My partner and I wrote our own patent. Love the process, frankly. And we got it after 5 years and a number of rounds. And I know that there's a lot of skepticism about pro se patents. I wanted to know. My product is not yet to market.
Yeah. Mark, what do you think?
Yeah, I think that probably some skepticism there in the marketplace. So really system design patents are going to be the highest value add.
Yeah. Timothy, I think Scott, do you want to comment on that a little bit about whether like your clients need to be represented by counsel per se?
From what standpoint? We
Like the
do.
standpoint of like IP, like if they have.
Yeah, I mean, we do certainly recommend that, and we do work with IP counsel quite a bit to protect those rights, but we don't get too involved in the nitty-gritty of sort of the legalese of it.
Yeah.
My follow-up question, if I could ask it, David,
Sure.
is were you going to pivot to the licensing aspect of the seminar title and the consumers? Because, for instance, one of the good uses of our product could be licensed by Wikipedia. I know it's a nonprofit, but it would be a huge user of our technology, and so I'm interested in aspects of that problem.
Yeah. So Scott, maybe you want to talk about that. You do help your clients kind of market to potential licensees?
We do. I think that trying to think of an example. I mean, look, we have another startup company that we're working with, an Israeli company that feels like its technology can be used to, not be the sole product and from a cybersecurity perspective, but can be homogenized across different dashboards, if you will, to protect infrastructure. And so they're thinking about licensing it in some capacity to bigger companies. So that might be one thing that we're working on.
Okay. Timothy, my kind of opinion, just based on what I've heard from Mark and Scott, is that it's great that you got your own patent, but you probably should try to get the use up and running, right? You should, because your patent will only be more valuable if you can actually sell it. But you should also kind of do a competitive analysis and do some sort of infringement analysis to see whether, who else is out there and who potentially might be infringing your patent as an added value. You should be doing those things. And that's not something you can do on your own. I guess it's something you can do on your own, but the infringement analysis is a legal analysis and you probably should have an attorney help you with it,
Okay, thanks.
I think the biggest risk in licensing is sort of losing some value in your assets by just sort of, putting them out there to a broader audience and having them sort of be less impactful, if you will.
Yeah, I think, Scott, one of the problems I'm sure you know that the moment your patent is published or the moment you get an allowance, immediately most people are flooded with calls and emails from licensing agents that are willing to take them on. Not a week goes by that I don't get. Many
SaaS companies in fintech in particular have, I think, unknowingly given away patents because they've just licensed everything.
That's what I'm saying. So it's really like, yes, people are going to be reaching out to you, but you need to kind of look at those deals. You need to see kind of what you're getting in return, what you're giving up. Sometimes it kind of looks and kind of feels too good to be true. It's probably not true, so
I think that's
right. Just look at that. So just look at that deal and definitely run it by your attorneys for sure. Saveway, you're going to come on camera and ask your question. You raised your hand. You're on mute. You're on mute.
Okay, very good. Am I in the free and clear room?
Yeah, we hear you now.
Well, thank you for the invitation. You know, some of you may have seen Save Away. We were, I guess, featured in Propelify, which is a festival that happens in the Northeast, as well as, I guess, in the Southwest with South by Southwest. So I think the platform is sort of the opposite of the historical credit card or the buy now, cry later schemes. Save Away now to pay later. So we have the awarded patent around the technology, both stateside, and it's also in motion across the Atlantic in the EPO. We also have continuations in process, and we have, I guess, notified the key infringers of the matter, and I guess haven't gotten any. I guess as is to be expected, need to escalate it to the next level. So, I would welcome any feedback that you might have around best ways of doing it. I guess the play-by-play is shifting very quickly to, I guess the copycats becoming the Goliath, because they're raising, despite being infringers, raising more venture capital on a relative basis. So yeah, I'd welcome what form of action would be most effective in that kind of a situation.
Yeah, so it's a little bit off topic for sure. Yes, we've been talking about infringement, and we've been talking about freedom to operate, kind of opinions that you should be doing. But we do have a whole, either I think in March or May, we have a whole kind of session, if you will, about cease and desist and what we call demand letters, and kind of taking the next steps in bringing in infringement action.
Sure.
So
my apologies. I guess, I probably should better have framed the question. So I think
I'll give you one more shot.
When your copycats, I guess, have deeper pockets and get themselves validated through, PR blitz, etc. What can the inventor of IP do to, assert in the marketplace, in the court of public opinion, that they are in fact the intellectual property owner?
Yeah, the first.
Yes.
Okay,
Yeah,
Mark, you have any advice here?
Yeah, well, I'm not going to give you legal advice.
No, yes, that's true.
Because
Yes,
every situation is different, right? But let's just talk in generalities about your situation. So the challenge, it sounds like you've already given notice, right? So the challenge about giving notice to your competitors on infringement is that can draw counteraction, right? And you got to be ready for that fight. And it can be expensive, and it can be debilitating to your business if you draw a counteraction and you're out trying to raise money. It might stop you in your tracks. So you really need to think through all the different scenarios on the risk factors with proceeding, right? As an IP owner, theoretically, you should be able to stop anybody from infringing on your patents. Unfortunately, the world doesn't quite work that way. There's risks that you can draw from actually asserting the rights you have in your patent. So one option, and I'm not recommending, again, every scenario is different, but this is where sometimes NPEs come in, where you transfer the asset. If you have only one or two patents, you probably don't want to give up all of your assets to another party. But it may be that you can bring in a partner who can take some of the risk and bankroll pursuit of your patent rights. When you do sell a patent to an NPE, you get a perpetual royalty-free license back to use that patent for the life of the patent, right? So there may be a way of structuring a transaction with a third party that you unleash the attack dogs on your competitors, and they're not going to draw and keep you away from drawing counterfire. So I suggest that before you take any action with giving notice or asserting rights, you really think through the long-term costs and ramifications of pursuing the strategy. You make sure you're working with a good attorney who can give you advice and give you some pragmatic advice on how this may play out for you and your business. And you don't want to start a war that you can't finish, right? So just be careful, and good luck on your situation.
Yeah, and actually, I just want to just comment, because I think, Scott, you probably can comment here too. I mean, just because the second company that is copying you and has better PR than you doesn't mean that you can't overshadow them in your marketing, right? So
Oh, absolutely. I mean, you can look, owning the narrative is something that's really important that we tell clients. And there are lots of products and services out there that go to market or get the word out there more quickly and capture mind share. But a lot of those wind up being inferior products or don't necessarily have the goods, if you will. And what's most important is having the goods, having the product, the service, the people, something that the technology, of course, that really is what solving a problem for somebody. And then we can work with you to really frame the message and the story around that and get it out, make sure it reaches the right people who can amplify it. So being first is certainly not always essential.
Awesome. Thank you, Scott. Mark, I love this question from Doreen. She's on mute. You kind of talked about it. Maybe you can kind of give a little summary. We have a single patent we are interested in selling. What that has its own issue, but more importantly is what information materials should we put together before contacting a broker about selling? Like before she contacts you, let's say. What else does she need?
The first thing that you want to do is accumulate, if you've got any encumbrances on the portfolio, if you've done any licensing to the portfolio, you need to consolidate that information, get that all put together. You need to decide whether you need to retain rights to that patent in the future, okay, before you sell it. Is this going to be important to your business? And what rights do you need to maintain? And you need to think about, if I sell my company in the future, do I need those rights to transfer with the sale of my business? That's usually a sticking point with buyers, is the breadth, the scope of that license if you sell your business in the future. The next thing you need to do, and probably before you contact the brokers, think about, is there any infringement? And again, I would suggest you go back and read the claims again. Don't think about your product, but read the claims as written, and brainstorm whether or not you can identify any infringement on the patent. If you can't, think about an argument that the industry is going to move on top of your patent in the future if you don't do anything. So you want to get the infringement story put together, you want to get the encumbrance story put together, and you want to think about what type of rights you need to maintain in that patent, or the rights to manufacture to use that IP going forward. Once you have that, you're ready for a discussion with the patent broker.
Awesome. Thank you, Mark. Scott, this is also a good one. Tammy Ellison asks, is any publicity good publicity?
No, it certainly is not. And hence that's the reason why there are crisis communications experts, because if you are, if you fail at something, or your product doesn't live up to what you've stated it is supposed to do, you can face a big problem. I mean, look at things like the Tylenol story, or Target when they handled data breaches. I mean, the list is countless. Southwest Airlines and the recent booking issues they served. I mean, there are some big things that occur. Now, obviously, these are large companies that touch millions and billions of people, and so it's tough to hide if you're those companies. It's probably a little bit easier for companies here to hide, but I don't necessarily think that any publicity is good publicity. I think that you can, if you get, one thing that we have to recognize now is that the internet is forever. If there is a story that's negative about you, or if it's litigation or some kind of adverse story, it will live on Google for a while, and it will live on the first page until several other stories replace it. So certainly can be damaging, and there's certainly good press and bad press.
Awesome. Thanks, Scott. Jeffrey, did you want to ask something? Your hand is up. Just take yourself off mute. Jeffrey.
Yes, yes.
Hi.
Can you hear me?
Yes, we can hear you. Your question?
Yeah, well, thank you guys for this meeting. It's very informative, Scott and Mark. I'm very new to this. I'm very virgin, right? My solution, right, is to solve a problem where mostly like in the Caribbean, Africa, South America, Central America, where they use propane tanks to heat their foods, for cooking mostly, and they can't ascertain the level of gas in the propane tanks, so they do a lot of shenanigans to try to uncover their current gas utilization. Now, my design helps to solve that problem. Now, my question to Mark or Scott, do you do marketing in those types of markets? So I could, showcase my idea or my product in those areas. And I do have a patent pending on this product.
Okay. It's definitely niche. Mark and Scott, for sure. What do you think?
That probably wouldn't be an that probably
sorry,
wouldn't
go
be an
ahead.
area that probably wouldn't be an area that we would get engaged with. That sounds like one of the areas that the technology would need to be evangelized, right? So you'd probably want to go off to propane equipment vendors, folks who make valves and those types of things, and see if you couldn't evangelize your idea. It's usually difficult to pay a third party to do that type of work because to get a company to pick up a product where you're bringing a patent to the table, a concept to the table, and convincing them to adopt it, and what you've got only is the patent rights. Most suppliers don't want to talk to you because they don't want to get if they're working on something similar, they don't want to get in a situation where they have to stop their activities because of potential willful infringement, right? So those are difficult discussions to have. We sometimes work with the vendors who have those discussions themselves. So they reach out to the vendors themselves, they evangelize the concept. And if they can get the company, one or two companies sort of interested in a deal, they'll bring a company like mine in to help negotiate the transaction and to get over the finish line. But I would. It sounds like almost something where you'd want to maybe go to a manufacturer and contract to have the solution manufactured, and then look for distributors and actually launch a business around that, as opposed to just trying to license the patent.
Yeah, Scott, any thoughts?
It's a little bit outside of our domain. I think I agree with what Mark's saying, is that there's a lot of evangelization that you need to do, and it's almost defining the product category, if you will, which is it can be done by marketers, but it's a lot harder to do, because I think it really starts with the business and getting potential partners, buyers, people that are in the business that can be influencers, that can be early adopters of it, that can really, once those people have signed off and you've gotten some credibility there, it's a lot easier to market, because there are far too many questions for us as marketers to have to answer at the outset that we're just probably not adept and able to answer just yet.
Great, good advice, Scott and Mark.
Dave, I have a question, Dave.
Hang on one second, Jacques. We have somebody with their hand up. Just put your hand up if you can. Kyle.
I can't find that. I can't find this thing.
Okay, don't worry. I will call on you afterwards. I
All right,
promise.
thank you.
Kyle, Judd Thomas, what's up? How are you? Your question?
Hi, thanks. Scott, can you expand a little more on the marketing materials, in particular, like what are the key selling points that you want to include in your pitch deck? And also, like, who do you pitch it to? Like, if I were to reach out to a company and try to sell or license it, like, am I trying to get hold of someone in marketing? Like, who's the key decision maker and kind of what drives that decision?
So before I get to that, are you talking about raising money, or are you talking to try to sell a product to an end user?
It would be So it'd be if I own some IP and licensing to a company who's then going to produce a product to sell it on to then the end
Okay.
user.
Okay, I mean, pitch books have changed dramatically in this day and age. I mean, we work with companies that are developing everything from animations to digital virtual pitch books, but the story needs to be the same, which is really, problem, solution. What problem are you solving? What's the market need? How does your product solve that? How has it been tested? What sort of like prototypical product is out there? What have you done in terms of revenue generation? Obviously the financials need to be there in terms of like what your projections are going to be over this, let's say 2, 5, 10-year period. That's mainly for an investor. For a customer, I think it's really about your story and sort of how you're solving the product, and also, solving the problem. Also, what's out there competitively that is in your space. In other words, you want to give them some clarity around who else is in your space and what they're doing and how you stack up relative to them. I think that would be important for a end consumer as well. For us, the pitch book is just the very beginning. We tell everybody the most important thing is to be a thought leader, to really drive the discussion and own the discussion. And so that's done through things like talking to reporters, being out there, being visible, publishing content, being active and weighing in on important topics on social media, for example, and the like. But I'd be happy to share some examples of some of the things that I've seen in terms of pitch books that are virtual but more dynamic than traditional ones. If that's helpful.
Yeah, because the reason I'm asking is because I'm putting together a website to do just that. So it would be providing a digital sell sheet, pitch book of sorts, and also connect people that have IP with people that would want to either purchase or license, or companies that would want to purchase or license it. So that's kind of the nature of the question, is like, how to think about that and design it.
Yeah,
Awesome.
I mean, I'd be happy to talk to you about that offline.
Amazing. Cool, Kyle. Thanks for sharing. Jacques, go for it. I think you're going to be our final question.
Okay, all right, thank you.
Question.
Thank you very much. This is a very challenging problem, and I really appreciate having Mark and Scott's expertise on this. It's something for the entire audience. I have a patent which responds to the mass shooting problem that we're experiencing. It's very serious. Since January 1st, we've had 40 mass shootings here in the United States. And my patent was very well vetted and examined very closely by the patent office. As you know, it's not easy to get a patent. And they issued the patent for a technique to prevent mass shooting. And basically, I narrowed it down to medication. Most of these people who are committing these mass shootings are patients of physicians, not the gang-related shootings, not the gangsters or the gangs, but these people who turn themselves in right away, they get caught right away. They're in schools, they're in malls. These are the people that I've identified with my patent. And I've been marketing it to the psychiatric profession and to physicians, but it's gone very, very slowly, very, very slowly. And so that's a challenge that I'm facing, where I have a patent which identifies a serious deficiency in medical practice, in the way medicine is being practiced right now. And I'm not getting the acceptance I'd like. I've talked to pharmaceutical companies and to major medical institutions, but I've been turned down. I have the inventors phenomenon. I'm experiencing the inventors phenomenon right now, but it's really true, though. I have very substantial evidence that substantiates the value of the patent for preventing mass shooting.
So, Jacques, one, there was no question there, but thank you. But I think I can call your question, and maybe Scott can kind of help with the answer. I'd love to hear Mark's.
All right, thank you. I'd like to present it to them.
Yeah, that's great. You can do that offline for sure. But
all right.
But Scott, maybe he's in need of like a
It
marketing.
sounds like, I mean, it sounds like you need our help. I mean, basically, look, at the end of the day, you have to have the goods. Your patent has to be behind something that's solving a problem, and you have to be able to clearly lay that out. For us, it's really a matter of just artistically laying that out, really making sure that it's very clear, like, here's the problem, here's the solution, and here's how it's doing that. And then it's a matter of, getting that first person on board, and then it snowballs after that. So I'm happy to have a chat with you about it. But you have to have the goods. You have to have the goods.
Yeah.
Oh, I have them, and I'm very diplomatic about it also. I'm not accusatory. I try and position myself as a friend to the industry with a solution.
I'll tell you, when I hear gun violence and a solution to the problem, I don't think necessarily about the medical side. I think about the gun side. So
Yeah,
that's something you have to really, because if you lead
but they
with,
don't always use guns.
Yeah. Listen, I've actually read the patent. It definitely needs a good marketing agency behind it. And I think the lesson here is that you can't do this on your own, right? Like all of you just like get a marketer, get a patent broker. Like just, you cannot do this on your own. And I know there's those anomalous stories of like people doing it on their own, but those odds are really, really low. Get the professionals to help you. Please, they can really do wonders for you.
But would I make a phone call or send an email?
So we will share Scott and Mark's emails when we send the recap, which I think will probably go out tomorrow with this actual recording.
Okay.
I think
Tomorrow's
that's
a work day.
thanks. Listen, we're out of time. It's been
Thank you. Thank you very much.
We went a little over. Next month, the end of our next meeting is always the last Thursday of the month at 12 p.m. Eastern. We're switching it up a little bit. It's called Making Music Money, How Copyright Owners Get Paid for the Use of Their Music. So nothing to do with patents, nothing to do with trademarks. We're going towards the different, the lesser loved form of intellectual property, copyright. So please join us. You'll see information about that. Mark, Scott, thank you so much. We will share your contact information, and we all look forward to working with you again in the future. So thank you so much. Thanks everybody for coming, and we'll speak to you soon.